Can I sue if I've been injured at work? That's a question that hundreds of people have to go through every day. And the answer is, it depends. It depends on the nature of the injury and what their job was. Here's everything you need to know. Hi, I'm Moshe from Rubinstein, the law firm that is ready, dedicated, and prepared to assist you with any injury claim that you have. If you have been injured at work, call us today. Visit us in person. Let's get to work and figure out what rights you have and who best to go after to get your rights protected. Being injured can be life-altering. You might be out of work. You might have medical bills. It's both physically and financially frustrating. And many of us want to know, what are our rights? Who can I sue when I've been injured? Especially if I've been injured at work, can I sue my employer? The answer is that in the state of Florida, if you have been injured through no fault of your own while going about your work activity, you probably have a claim. If you have been injured as a result of performing work-related duties, chances are that your employer will take care of your injuries through their workers' compensation program. You have benefits that you signed up for at the beginning of your job. One of them is workman's compensation, and that will take care of your medical bills. But it's not always so simple, because perhaps you don't want to go to the doctor that your employer is telling you to go to. Or perhaps their insurance policy only covered so much, but your injuries are much greater. Or perhaps your employer did not have the proper insurance. If one of those things happen, you absolutely have a claim against your employer. What happens if you've been injured through no fault of your own at work through non-work related activities? You still have a claim. Just because you can't go through the workman's compensation program does not mean that you can't bring a claim against your employer or perhaps a third negligent party. So for example, if you work with your hands and you're using tools and one of those tools malfunction, you might have a claim not only against your employer, but more importantly, against the company that produced that tool. Or perhaps you're driving a company car on your way to work for the company and something happens to you. Chances are not only can you go after your employer, but you can also go after the negligent party that caused the accident that happened to you. Again, so long as the accident happened while you are on the clock, meaning while you're in the process of doing your work, you should not let your employer off the hook. Just because you can point the finger at another party that was negligent or that caused your accident does not mean that you can't get compensation from your employer. If you've been injured at work, this is what I want you to do, and this is what I want you to not do. First of all, always seek medical attention first and foremost. Always collect as much documents and evidence as you can. Also, importantly, speak to HR and find out from them what your rights are. And then, importantly, contact an attorney. Don't believe everything your employer is telling you. Just because they say that you have to go to such and such doctor for such and such care does not necessarily mean that that's what you have to do. Remember, you have rights. You're not their indentured servant. And just because they've offered you compensation or offered to take care of your medical bills does not mean that you don't have further claims against them. Here's what I want you to not do. Don't wave a hand and say, hey, it's okay. Don't sign any release. Don't accept the small check that they may put in front of you for your damages. Always consult with a legal professional, an attorney that you can trust, with a firm that you can trust, with my firm, to make sure that you are being treated fairly, that you are being compensated fairly, that your injuries, both the ones you have today and the ones that you may not know about for the future, are all included in whatever settlement your employer is offering you. If you've been injured at work, the most important thing that you need to do is prove that your injury happened through no fault of your own at work as you said it happened. Sometimes you go to work expecting things to happen. That is not what we're talking about here. We are talking about a type of injury that you did not sign up for, that is not part of your work. But guess what? If God forbid you have been hurt at work and it was expected, you still may have a claim. Prior to being an attorney, I was a teacher, and I was once out on a hike with my students. I slipped, I fell while on a hike with the students, but I did not know my rights, and I did not do anything about it. Later on, I learned the hard way that I absolutely could have gone through my workman's compensation program, and I would have been compensated for my injury. I would have been able to stay home and recuperate while still keeping my job. I had rights that I did not know about. Don't be that person. Don't be like I was. Call us today and let's discuss together how we can proceed with your claim in a dignified manner, that we can get your medical bills paid, we can get you back to work, and life can go on as you knew it prior to your injury. If you like this video, subscribe, visit our website, or call us today. Let's talk together and figure out how we can represent you, how we can give you the representation that you deserve. If you've been injured at work or you've been injured in another circumstance, do not wait. Call us today. Let us begin representing you right away so that we can proceed with your claim. Or visit our website so that you can learn more about us. Trust us. We know what we're doing. We want to represent you.